Okay, welcome to our Chapter 2 discussion on intestate succession, so dying without a will. Keep in mind that there are three main ways property is disposed of. We have property disposed of by contract, so these are things like trusts, bank account beneficiary designations, insurance policy beneficiary designations, jointly owned property contracts, things like that. Property disposed of by a will is where you have a last will and testament, and that says where stuff goes. But everything that has not been handled through a contract, and if there's no will, is handled through intestacy, and that means the state of passing without a will. Okay, everything through intestacy, we have a lot of different predetermined codes for who gets what, right? Okay, so these things are, first, everything goes to a spouse. So if you have a spouse, it all goes to the spouse. Now, that changes a little bit if the spouse is not also the parent of all of your children. Okay, so if you have descendants that are from a different spouse or a different relationship, we use a different formula. So in that case, the spouse is going to get $75K, and that number, as on page 13, the footnote says that's in 2009 dollars, adjusted to inflation. So so it's the first 75K plus a full 50% of the remainder, and then the rest goes to the descendants. Now let's say there's no descendants, or sorry, that there's descendants but no spouse, or how are we deciding how to split up amongst those descendants? On page 14, we have the descendants per capita as the primary beneficiaries after a spouse, then parents, siblings, and so forth. So we've defined descendants per capita here with some of these illustrations, and that's to help just kind of illustrate the difference between per capita and per stirpes. Per capita is one system of defining property ownership and property rights and things like that, and per stirpes is another. They're different distribution systems, and Utah is a per capita state. Most states tend to be per stirpes states, so we explain both here in the text. The per capita is basically how they would inherit through their parents, but it's hard to explain without the graphics here on the screen. But like, let's say we have multiple deceased members of a class. Like, let's say two of the children have passed away, like the case on what is this, page 15. So here on the page 15, and I use the page numbers at the bottom of the page, not the page numbers of the PDF, okay? So the page 15 illustration here shows that Alice and Charles have both passed away. They were both children of the decedent, right? Edith, Francine, and Joseph are the only living grandchildren through deceased parents. And so even though they have different parents, if this were per stirpes, let's say, Edith and Francine would have split Alice's share, and then Joseph would have been the sole inheritor of Charles's share. But in a per capita system, because they're both, because all three of them are treated as equal inheritors, because all three of them have inherited through deceased children, then now they all take an equal share and split a third each of the remaining 2/3 of the estate that would have gone to those deceased children. Okay, so that's per capita. Per stirpes, as I had said before, per stirpes literally means by the lines. So it's just, if you look at it kind of like a bloodline, it's just simply a division of who inherited what through which parent. let's see, defining the parent-child relationship. We covered this a little bit in the Chapter 1 discussion, but anyway, some of this stuff just reiterates what we had covered, where, how do we define birth and who is whose child, especially in light of gestational agreements, surrogacy, stuff like that. That's pretty well explained in the text. I don't think we need to go any farther than that. And then let's see. Oh, this 120-hour survival requirement on page 18. Sometimes we worry in this intestate structure who lives longer than someone else for inheritance purposes. So we just have this rule in the probate code in Utah, and this varies state by state, that you need to survive another person by at least 120 hours or 5 full days to be considered one of their heirs, and that's to avoid certain pitfalls with probate distributions and things like that. Let's see, heirs in utero, that's pretty self-explanatory. Advancements, I'd like to talk about this for just a little bit. Okay, so advancements are ways to count lifetime gifts against someone's inheritance. So we have lifetime gifts, we have loans, we have advancements, and we have devises under a will, and we have inheritance, right? These are all different forms of property transfer. Some of them will count against your inheritance, others will not. So, for example, lifetime gifts do not count against an inheritance. So if someone's, let's say someone is not planning on passing away, they give a gift to a child or a loved one, and they they give the gift and then they die shortly thereafter. That is still considered a lifetime gift. So any gift that is given without the expectation of imminent death is generally considered a lifetime gift unless it's not. Advancements are one of those exceptions. So if you say with witnesses or you write down, this property is given to you, but I want it to count against your inheritance, or I give it to you in contemplation of my imminent death or something like that, then it can be considered an advancement. And advancements count against inheritance shares, okay? And then there's a little part in here that I think is important on page 19 that says, by way of clarification, if an heir's advancement is worth more than their inheritance, they're not required to refund the advancement in any way, right? So unless it's what was the term? Unless it interferes with spousal elective shares and stuff like that. And we'll get to that in later chapters. But generally, advancements do not need to be refunded if they exceed the value of what they would have inherited. Okay, so that is the gist of intestacy and dying intestate and the terminology we're dealing with there. And we'll cover another chapter in the next video.